Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. Today we're going to talk about a new case. It's in New York. Let's take a look. The case is found in the NYSEF, New York State Courts electronic filing, and the case number is 604034-2023. Nassau County Supreme Court. And you can find this if you look in NYSEF and you want to search as a guest. You can bring it up. And it's Bonnie Salzoni, and she is fighting to keep her house, which she got through inheritance. Her parents passed, and she is the heir to it. And this is an interesting case. It's been going back and forth with the bank, and the bank has basically tried to foreclose on her for different reasons. And the last thing they filed was a motion for a summary judgment, and now she's going to file her opposition to motion for summary judgment. So let's go over that. Okay, so this is the heading to the case. Defendant's opposition motion to plaintiff's motion for summary judgment. And as you can see, the table of contents here. Background, initial loan and mortgage agreement, defendant's ownership and loan modification, change in property ownership, subsequent agreements and notices, foreclosure actions and disputes, recent developments, statement of material facts in dispute, plaintiff's claim of standing, FOIA request and trust status, assignment and mortgage documentation, endorsement of the promissory note, or lack of it I should say, plaintiff's evidence and affidavits, argument, implications, lack of authority, potential fraud, questions for the court, personal jurisdiction, legal precedent, standing, conclusion, and prayer for relief. This is your basic outline for a opposition to motion for summary judgment. Table of authorities. These are the different cases that she's using to support her side of the argument. Okay, now let's see here. We're going to go past a lot of this stuff into the meat of it, I should call it, the meat. Okay, let's go to statement of material facts in dispute. The plaintiff is claiming to be the Bank of New York Mellon as trustee for the C. Walt, Inc. Alternative Loan Trust 2006 HY 13 Mortgage Pass-Through Certificates, FOIA request and trust status. On 9/5/2024, defendant submitted a FOIA Freedom of Information Act request to the Securities and Exchange Commission. A copy of this email is hereto attached as Exhibit B. The defendant received a response that states the trust ceased operations on January 29, 2007 when it filed a Form 15. A copy of the Form 15 is attached hereto as Exhibit C. Assignment and mortgage documentation. The assignment of mortgage, Doc 4 in NYSEF, that was filed on 3/8/23 is dated 9/27/07. If the trust ceased operations on January 29, 2007, they would not be able to accept a mortgage loan into this purported trust on 9/27/07. And as you can see by the footnote, the SEC Form 15D, is a certification of termination of registration of a class of security under Section 12G, or a notice of suspension of duty file reports pursuant to Section 13 and 15D of the 1934 Securities Exchange Act. And basically, in layman's terms, it means that the trust has dissolved. Endorsement of the promissory note. The promissory note, Exhibit A, Doc 2 in NYSEF, is not endorsed anywhere to Bank of New York Mellon, nor is it endorsed to any party of the C. Walt, Inc. Alternative Loan Trust 2006 HY13 Trust. Defendant asserts that plaintiff lacks prima facie evidence of standing to foreclose, and the foreclosure complaint should be dismissed. Plaintiff submitted an affidavit of Winston Johnson, a document verification specialist who works for NewRez, LLC, formerly known as New Penn Financial, LLC, doing business as Shell Point Mortgage Servicing, hereinafter SMS. Doc 52 filed on 3/1/2024. Neither Shell Point or NewRez are parties in this case. See Wells Fargo Bank versus Carrington. And then, of course, Carrington's, it states the following. Here, the plaintiff fails to establish prima facie that it had standing to commence the action. In support of its motion for summary judgment, the plaintiff relied on an affidavit from Daniel Del Spacci, an employee of Aquin Loan Servicing, LLC, hereinafter Aquin, the loan servicer. Del Spacci averred, among other things, that based on his review of Aquin's business records, the plaintiff had been in possession of the note since February 23, 2007, prior to the commencement of the action. However, the plaintiff failed to attach the business records upon which Del Spacci relied upon his affidavit. Although the foundation for admission of business record usually is provided by the testimony of the custodian, the author, or some other witness familiar with the practices and procedures of the particular business. Plaintiff's defects in the note, Exhibit A, and the assignment, Exhibit C, and the affidavit by Winston Johnson, Doc 52, demonstrate that plaintiff lacks standing to foreclose. Argument. Implications. The FOIA request and Form 15D confirm that plaintiff, Bank of New York Mellon, as trustee for the C. Walt, Inc. Alternative Loan Trust, blah, 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 blah series, ceased operations on January 29, 2007. Therefore, the plaintiff did not exist at the time the complaint was filed on March 8, 2023. Lack of authority. The plaintiff's attorney lacks authority to represent a non-existent entity. Potential fraud. The continued representation by the plaintiff's attorney suggests a potential fraud or misrepresentation. See CDR Criancis SAS versus Cohen, which is a fraud case. Questions for the court. Who is the attorney truly representing? Does the attorney have authority to represent a non-existent entity? Is the attorney perpetrating a fraud or misrepresentation? Is an imposter using the trust name to pursue this lawsuit without legitimate authority? Because the trust filed the Form 15, Bank of New York Mellon as trustee lacks the authority to act on behalf of a defunct trust, and as a result, the court lacks subject matter jurisdiction over this foreclosure case. Personal jurisdiction, legal precedent. To have jurisdiction, a plaintiff must exist. See Indy Mac FSB versus Mendel Measles. In this case, the court determined that it was an extraordinary circumstance for a non-existent corporate entity to retain counsel and proceed with foreclosure. As a result, the court vacated the default, dismissed the action with prejudice, and considered sanctions for frivolous conduct. And of course, you can read about the Indy Mac FSB versus Measles case. We have it on the website for foreclosure, Help 777. If anybody wants to read the whole thing, it's very interesting. We won't get into it completely here, though. Basically, the BNY Mellon as trustee as the plaintiff is not a valid entity due to the trust termination. So therefore, the court lacks personal jurisdiction over the defendant. Because the trust filed the Form 15, Bank of New York Mellon as trustee lacks the authority to act on behalf of a defunct trust, and as a result, the court lacks subject matter jurisdiction over this foreclosure case. Standing. The plaintiff must prove its standing as part of its prima facie showing on a motion for summary judgment. And it has some case law here about standing, guys. A plaintiff establishes its standing to foreclose a mortgage by demonstrating when the action was commenced that it was either the holder of or the assignee of the underlying note. Conclusion. In the context of New York law, summary judgment is an extreme remedy that should only be granted when the moving party establishes beyond a reasonable doubt that there are no material facts in dispute and they are entitled to judgment as a matter of law. In this case, the plaintiff has failed to meet this burden. There are significant factual disputes, particularly regarding the plaintiff's standing to foreclose, the validity of the assignments of the mortgage, and the endorsement of the promissory note. These disputed facts necessitate a full examination of the evidence and preclude the grant of summary judgment. Therefore, given the unresolved factual issues, the plaintiff is not entitled to summary judgment and the court should deny the motion. There is a clear lack of authority and jurisdiction. Dismissing the complaint will prevent unnecessary litigation and protect the defendant's rights. And of course, we have a prayer for relief here. Wherefore, defendant prays that this court will grant her relief and deny the plaintiff's motion for summary judgment based on the undisputed facts and the law. Defendant Bonnie Salzoni, otherwise known as Biscagno, respectfully requests that this court deny plaintiff's motion for summary judgment, dismiss the foreclosure complaint with prejudice, consider sanctions against plaintiff's counsel for pursuing a frivolous lawsuit. Respectfully submitted. Okay, and then there's affirmation of mailing and good old stuff like that, guys. Okay, one more last thing, guys. The email request to the Securities and Exchange Commission, FOIAPA@sec.gov. And you guys, if you have information about your trust, you can also submit the same kind of email as well. Dear Sir or Madam, I am seeking information regarding a trust called the Seawalt Alternative Loan Trust 2006-HY13 to determine if this trust still exists. I did find some information on the SEC's website which states it filed a Form 15 dated January 29, 2007. I have copied and pasted this information to this email for you to confirm if this is true. Please let me know as soon as possible. And if you look here, guys, you will see the Form 15 right here, Form 15. You will see that here's the loan, here's the trust name, Alternative Loan Trust 2006 HY13 right there. And if you scroll down, you'll see the check mark in the box for the 15D, and you'll see the date on here, January 29, 2007. And it's signed by Darren Bigby, Vice President. Okay, guys, so that's going to do it for today's episode, guys. If you have any questions, you can certainly send me an email, and I'll try to answer your question as best I can. And my email address is foreclosurehelp777@gmail.com, or you can join us on my Facebook page, which is a private group, and we talk about everything foreclosure related. I hope this video has been informational to everyone, and I hope everyone has a blessed day.